おはようございます。昨べは楽しかったですね、お兄さん。ちょっと怖い時もありましたけど、いろいろ教えてくれて。
This is my third time using this meme for law school.
And that's going to be the end of the intro bit, and I think everyone would like that. We all have cases to study, we all have papers to write, and in the end, we all just want to go home. So let's talk about the case here. This case is a story of 3 C's: crime, circumstantial evidence, and children. And when I mean children, I mean child
parental guidance. There may be strong language like shit or ass, and brief nudity like showing off an ass, or light violence like getting kicked in the ass.
Oswald Villaroman took his laptop to a MyMac dealer shop to fix some power issues. The technician, Alan Sobchak, went through the repairs, which includes a routine check to ensure the software was working properly. During this check, he noticed that the music folder had video files, and when he opened it to investigate, he was treated to a curated collection of films with descriptive names like Caught 14-year-old and 9-year-old, 10-year-old, 11-year-old. As to why CP was in the music folder, maybe they pair very well with smooth jazz or something, I wouldn't know, but it might have something to do with the fact that they were downloaded via LimeWire, popular for sharing music and videos online at the time. Alan, probably alarmed, contacted police, and they seized and analyzed the computer. They discovered that 36 CP files were downloaded into the computer's sole account, Oswald Villaroman. Some of the videos were viewed, and the computer was used almost every day for almost 2 years before Oswald sent it for repairs. Oswald was arrested a few months later and charged for distribution, possession, and accessing CP. Since the police searched the computer under a warrant without Oswald's authorization, a voir dire was performed. This, along with the testimony from the voir dire, was admitted as evidence for the trial. At trial, Justice Keith Yamauchi found Oswald guilty of possession of CP, but acquitted him of the other 2 charges of distribution and access. His reasoning basically went like this. CP was manually downloaded and viewed on the computer. The computer had 1 account. The account's name was Oswald Villaroman. The accused name? Oswald Villaroman. And nobody else had access to the computer. Ladies and gentlemen,
we got him.
If it was that easy, I wouldn't be making a video about it now, would I? No, instead, the Court of Appeal came in and basically said, no, Keith, you're wrong. We can think of so many other reasons to explain how the CP got onto Oswald's computer, and none of them have to do with him. Your reasoning is based on insufficient, skimpy, circumstantial evidence. We're overturning the verdict. If the Crown has a problem, they can take it to the Supreme Court. And that's why I'm making a video about it. The main issue the Supreme Court had to address was whether or not circumstantial evidence can be primarily used to establish guilt. Since this hasn't been really addressed in case law yet, it's not a simple yes or no question. If it was yes, there were some sub-issues that needed to be answered as well. Before I go any further, I think it'd be helpful for you to know what circumstantial evidence means. If you're unfamiliar, I highly recommend watching this video, which breaks it down very well. But to put it briefly, evidence is deemed circumstantial when the evidence itself doesn't outright prove anything, but allows you to make an inference. The Supreme Court made this analogy. A witness might say that he or she had seen someone enter the courthouse lobby wearing a raincoat and carrying an umbrella, both dripping wet. If you believe that witness, you might infer that it was raining outside, even though the evidence was indirect. The raincoat and umbrella don't necessarily prove that it was raining, but a reasonable person would probably see that and think, well, the guy's wearing the coat and holding the umbrella for a reason, and they're both wet, so it's probably raining outside. Thus, the coat and the umbrella collectively form the circumstantial evidence for you to reach that conclusion. Alright, let's move on to the analysis. The Court of Appeal claimed to find many other possible explanations for how CP got into the laptop without Oswald's involvement. Since Justice Yamauchi didn't consider them at trial, the Court of Appeal didn't find his reasoning to be reasonable. This line of reasoning is based on the practice established in Hodge's case. This case also relied on circumstantial evidence, and the judge was concerned that the jury might be swayed by the Crown and bridge the gaps in evidence to support the Crown's narrative. So, to counter this, he expressly instructed the jury to be satisfied that the facts disprove all other rational conclusions, and because this judge did it, all the other judges have to do it too. Well, not anymore. The Supreme Court noted that this requirement has relaxed over the some 180 years since Hodge's case came out. Nowadays, it is sufficient to simply inform the jury that an inference of guilt is the only reasonable inference that can be drawn from circumstantial evidence. More so, special instruction is not mandatory, though it may be helpful, and the Supreme Court will turn to the presiding judge to determine the appropriate instruction to the jury. Now, you might be thinking, there's been no mention of a jury. Oswald had a jury at trial? No, he didn't. There was no jury. But the Court of Appeal treated Justice Yamauchi's reasoning like instruction to the jury, which the Supreme Court promptly rebuked. Another big precedent from Hodge's case was the introduction of the reasonable doubt standard, where the Crown has to prove guilt beyond a reasonable doubt. And to avoid confusion, the Supreme Court addressed the relationship between circumstantial evidence and proof beyond a reasonable doubt. And the relationship is basically...
They're different.
The Supreme Court described reasonable doubt to be an innocent explanation or inference based on reason and common sense. They provided a list of the required elements to establish a reasonable doubt. 1. Being based in evidence or its absence thereof. 2. Logical assessment. And 3. Consideration of human experience and common sense. Any other explanations or inferences that don't have these elements are basically speculation. So, if we use the raincoat analogy again, another reasonable explanation for why the raincoat and umbrella are wet... Actually, I can't think of another one. Alright, new analogy. Let's say you're at a grocery store. You see two people leaving the store with grocery bags in hand, but then a few minutes later, one of them comes back into the store empty-handed. A reasonable inference could be that they went to their vehicle, loaded up the car with the bags, and person 1 returned to grab one more item while person 2 waits in the vehicle. Another reasonable inference could be that person 2 is holding all the bags right outside the store while person 1 grabs another item. Maybe person 1 needed to go to the washroom. That's reasonable. But an example of a possible but unreasonable inference would be that they went around the corner and person 1 decided to commit a top 10 anime betrayal and began pelting person 2 with the luscious, supple produce they purchased together, and now person 1's coming back to restock ammo for their epic battle. Is it possible? Yes. Reasonable? Absolutely not. Clearly, if we took this to court, you wouldn't expect lawyers to disprove the possibility of a glorified food fight. So when disproving reasonable doubt, the Crown only has to disprove reasonable, innocent explanations, not every single possible one. Now, I've used the word reasonable a whole lot, but I've also used the word rational. And you might find cases that use the words rational too. Reasonable, rational, right and national. It might get confusing given they are two words with very similar meanings. So the Supreme Court sought to clarify the relationship between the words reasonable and rational. And the relationship is basically...
They're the same.
Moving on, looking at the facts of the case, the Supreme Court found that the Court of Appeal's reasoning for overturning the trial decision was unfounded. They found that most of the other reasons the Court of Appeal came up with that demonstrated Oswald's innocence was more like speculation than reasonable inferences, to the point that they essentially retried the case. To demonstrate, let's read an excerpt from the Court of Appeal's list of alternative explanations. There is no evidence at all about whether this computer stayed regularly in one place or moved about. If it stayed at home during the day, who else had access? Did a family member let friends use the computer? Did non-residents hang around the area where the laptop was? If this laptop did not stay at home during the day, did it go to work, like with the accused, or with a family member? Did it go during the day to a school, college, or university? Was it kept locked up or hidden wherever it usually was? And wherever it was each day, how many other people had easy access to it there? We do not know. Another thing that the Court of Appeal does not know is whether or not he used NordVPN, which is the sponsor of today's video. The number of separate items of pornography which the police found on this laptop was 36, 35 movies and one still photo. About half were incomplete, which could be significant. Yeah, because watching incomplete CP, that's okay. The Court of Appeal is okay. They don't mind that. But complete CP, oh my gosh, absolutely not. That is horrendous. That is immoral. And that's just outright wrong. You absolute sicko piece of... The Supreme Court determined that it was not the Court of Appeal's prerogative to retry the case since the trial didn't make any error that would warrant a retrial. Sure, the evidence was circumstantial and had gaps. Justice Yamauchi's reasoning contained, and I quote, problematic statements, and not every judge would come to the same conclusion. In the end, Oswald's conviction for possession was reinstated. He would later try to appeal the case based on charter issues that were raised in the Supreme Court hearing, but the Court of Appeal didn't side with him this time.
So, why are we talking about this case? Well, this case sets a standard for using circumstantial evidence to establish guilt. Before, the courts would be cautious about using circumstantial evidence as the foundation for a conviction. However, there are many situations where collecting direct evidence is difficult, if not impossible. So we do have to rely on circumstantial evidence if we want to effect justice. This case also provided the Supreme Court the opportunity to clarify what reasonable doubt means and what burden is imposed on the Crown to disprove it. As for what happened to Oswald after he lost his second appeal to the Court of Appeal, the trail goes cold. I'm guessing he's probably served or serving his 1 to 10 year sentence, and a Google search doesn't show anything except the media articles covering the case. As for Alan Sobchak from My Mac Dealer, you can find him on LinkedIn and Twitter.
Anyway, there are lots of new things to do in
prison.
like making new friends such as you. See you soon.